Hi there, welcome to the Relitigated podcast. I'm your host, Jarrett, and I'm joined by my co-host, Nikki. Hello, Nikki.
Hello.
Now, normally we invite three friends who roleplay as justices, but for this episode, we're doing something a little different. With us today is Dr. Paul Lombardo, who is the Regents Professor and Bobby Lee Cook Professor of Law at Georgia State University's Center for Law, Health, and Society. He is a history and legal scholar who throughout his career has researched and written extensively on topics such as eugenics and medical ethics. As the author of the book Three Generations, No Imbeciles, Eugenics, the Supreme Court, and Buck v. Bell, he is also an expert on the Supreme Court case Buck v. Bell, which is the case we discussed in our last episode. We're incredibly excited to have him here to help us contextualize and make sense of this very difficult case. Dr. Lombardo, welcome to the podcast.
Thank you.
Super excited to have you here. Before we get into the case itself, I was wondering if you wouldn't mind giving us a little bit of the backstory on yourself and how you came to learn about the case and why it's been such a big part of your academic career.
Well, like most things in life, there was a lot of chance involved. I was a graduate student. I needed to write a paper for a seminar, and I just happened upon a news story that was lying next to me in a little restaurant. And the news story had to do with a case that was in the local federal courts where a group of people were suing because they had been surgically sterilized by the government over a course of years. And it turns out that the person who was representing a group of people, a class of people, was named Doris Buck. And she happened to be the sister of somebody named Carrie Buck. Well, at the time, I had no idea who Doris or Carrie were, but it turns out that Carrie Buck was the person whose case went to the Supreme Court in the 1920s and validated the state laws that allowed people to be sterilized in state institutions. And so I thought, well, this is an interesting case, and it's local. Why don't maybe I could write about this. And so I got my mentor to approve it. I stumbled over to the library. I found completely by chance the records of the lawyer who had brought this case to the Supreme Court and also wrote a bunch of laws having to do with various mental hospitals and asylums back then. And so I ended up using his papers. He had been dead for some time. I used his papers as the basis for this seminar essay, but then later turned that into an article, and then ultimately that became my dissertation. It was a biography of the lawyer and his role. His name was Aubrey Strode. His role in the case of Carrie Buck versus Bell, John Bell, who was the superintendent of a place called the Virginia Colony for the Epileptic and the Feeble-Minded. So that's how I got involved. I went on after finishing that degree to go to law school. Also, something I did essentially on a bet. It wasn't really planned. When I did a little more writing about this while I was in law school, I graduated. I went and practiced law for a while out in California. And then I was asked to come back and teach there at the University of Virginia, where I stayed for about 16 years, and was able, and as part of my job, was able to not just teach in this area, but also to study and write. And my books and most of my articles have come out of questions at the intersection of law and medicine and science, particularly those that have some sort of historical context.
Did you have a sense that you were interested in medical ethics and topics like eugenics before Buck v. Bell? Was that an interest of yours, or did this case kind of open up an area of law and thought that you hadn't kind of explored before?
No, I was interested in the context of medicine and the health sciences more generally. And I'd worked for about 3 years with organizations that accredited health science centers, and so I hung around with and worked with people who were faculty members and deans and college presidents, things like that, who went on trips to evaluate medical schools and dental schools and other schools and health science centers. And so I was very interested in the science and the curriculum and how all this stuff worked together. but I was curious, and this is before I went to graduate school to study history. I was really curious about why our system of training that exists in this country now took the form that it did. And so I was really, really interested in the whole idea of how universities were formed back in the sort of medieval period and how professional schools became part of that development. So I did have an interest before I got into this area. I happened to be, again, completely by chance, at a place which had some major people in biomedical ethics as well. And so I'm not a scientist. I'm not a physician. I've never really studied those areas as a professional, but I've studied the way that they were trained and the questions that come up. So that's kind of a very long answer to the how the heck did you get here?
Excellent. Thank you.
So let's start with the case and walk backwards a little to understand how we got to the Supreme Court in the first place. In our previous episode, we referred to the petitioner as CB. Can you tell us a little bit about who CB, or Carrie Buck, really was and why she was sent to the Virginia colony?
Yes, Carrie Buck was a girl who grew up in Charlottesville, Virginia, with a mother who apparently ended up raising her kids by herself, at least after a few years. She was married and her husband was there, but then after a few years, he wasn't there. We're not quite sure exactly what happened. Um, the children were taken from the mother. The mother's name was Emma. When they were both young, and there were two girls, Doris and Carrie. Carrie was the older one. And so when Carrie was somewhere between 4 and 5 years old, she was taken from her mother and placed with a foster family whose name was Dobbs. When she reached the sixth grade, they took her out of school. She'd gone to the local schools until she was in the sixth grade and done reasonably well. I found her grades, and her grades were average. She was given actually good marks for deportment, which is something back in the old days they talked about. Deportment was basically if you were well behaved or not. And her teacher said she was, but she only got to the sixth grade, which was not that unusual, in the 1920s, and actually before the 1920s, because she was born in 1906, I believe. So she was probably it was the early 20s before she came out of school. In any event, um, Carrie worked in the home of the Dobbs family, essentially as a housekeeper. She, cleaned up. She took care of the chickens in the yard. She did the kinds of things that somebody who was working in a family would do. And for that, she got her room and board.
Was that a common arrangement at the time?
I think probably it was, and some of these foster arrangements were like that. That children would be raised in an area, but they would be expected to work. And so she worked, sometimes taking care of small children, oftentimes just doing cleaning, housekeeping, and cooking and things around the house. So she's in Charlottesville, and she is out of school. And one summer, her the woman whose home she's living in, Miss Dobbs, goes on a trip for a few days out of town, and she's left at home by herself. And during that period, um, she gets pregnant. Um, as far as we can tell, this was a relatively short, week that she was unsupervised, and she was about 15 or 16 years old then. We later find out that the young man who was the became the father of her baby was a relative cousin of the foster family where she was living. But that gets us a little bit ahead of the story. Carrie is found to be pregnant by her foster mother. Everybody's in shock. These people are modest in means. They're certainly not wealthy people at all. In fact, they're living in a relatively marginal part of town, right on the railroad tracks. and she is and the family is supported by Mr. Dobbs, who works as a repairman on the local streetcar line. And Carrie finds herself pregnant and tells her foster mother this, and so the parents immediately decide it's time to get her out of the house, and so they go to the doctor, they go to the other officials, and they end up um, essentially swearing out a an affidavit which says that she needs to be taken to the state colony for the epileptic and the feeble-minded because she's feeble-minded. Now, at that time, there was a pretty broad definition for what feeble-mindedness was, but their argument, which was echoed by many of the people who in the professional roles, was that a girl like Carrie, who came from a not a disreputable family. Her mother had had trouble with the law. There were some claims that she had been working as a sex worker. Other some evidence that she may have had a drug problem. All this was very fuzzy, but the big issue was that Carrie was pregnant and she was not married, and she needed to get out of that house. And so she was sent to Lynchburg. That's how she gets to Lynchburg. I'm saying Lynchburg. It's actually Amherst County, but it's the Virginia colony, which is across the river from the city of Lynchburg, Virginia. Carrie has the bad fortune not only of getting pregnant in this untimely way without a husband, but also of arriving at the colony at just the point when the state of Virginia had just passed a new law which allowed people to be sterilized if it were to the benefit of the state. If sterilizing them would mean that they would not produce any more people like them, meaning people who were poor, people who were maybe the phrase they used was defective, meaning someone with questionable cognitive skills, perhaps criminal tendencies, perhaps moral deficits, long lists of possible things that might be wrong with them. And that's why they got sent to the colony. And that's why they were scheduled to be sterilized, because the theory of the law was that if you didn't let people like this have children, then there wouldn't be any more children like them, meaning there wouldn't be people who would have to be institutionalized in prisons or mental hospitals or homes for the feeble minded. So Perry shows up at a time in which this law just goes into effect, and her baby is taken from her before she goes to the colony, and she is thrown into the middle of what she doesn't realize at the time, but later discovers is really a whole national movement to allow people to be sterilized. And so that's how her case gets to the board of the colony. They approve the sterilization. And then, according to the pieces of the law which go into effect, she is able to challenge it. And so they appoint a guardian for her and a lawyer for her who will take her case as a test through the court system in Virginia and then maybe all the way up to the federal courts in the United States Supreme Court. That's how Carrie's case eventually gets to Washington, D.C.
I do have a question. I feel like I'm about to derail things just a tiny bit, but I just wanted to
How about it?
follow up real quick. Um, you you said well, you used the term defective, and I wanted to know, was that how it was said back then? Is that a term of art? I will say, hearing it now, it's got a little bit of a feeling to it, but
Sure. Most of the language that was used um, to describe people who were institutionalized or people who were subject to the law, for that matter, um, is language that's jarring today because we usually don't hear these terms that much anymore. Most of them have been scrubbed out of the law books, but they were very common. They were very, very common until a very few years ago. So, someone who was mentally deficient, that was a term of art. Um, and there's a great deal to be said about that, but how did you measure it? How did you recognize it? Who fit into that category? But without getting into all that detail, certainly that was the language they used. They talked about people who were feeble-minded, people who were sometimes just colloquially mentally slow. They would say, but they would also say defective or mentally deficient.
Curious, you obviously with this case, became a whole thing, but where it started from, as you said, you know, Carrie was institutionalized. Can you walk us through a little bit what the Virginia colony specifically was at the time and why it was important for them and specifically the individual in charge to have this case go to the Supreme Court?
Well, the Virginia colony, there's a lot of speculation about why you would have a place like that. Um, and I often push back on that speculation because I think you need to understand what the context was in 1910 or so when they, or even earlier when they started talking about building such a place. And the conversation at the time was, we don't have anywhere to put people who are um, cognitively delayed or maybe cognitively um, uh, arrested. They're never going to develop into a kind of adult thinking person. What do we do with these people? Well, the reformers, people like Dorothea Dix in the 19th century, said what we do with them is terrible because we do two things with them. Well, actually, three. The first thing we do is we just let them roam the streets. We turn them out of our homes and we let them roam the streets, and they die there because they're abused and they're without any protector, and that's terrible. Um, the second thing we do is we put them in jail, and we put them in jail because people don't want to look at them. People don't want people wandering around. When the first institutions were built in the United States, you have Benjamin Rush. This is in the 18th century. You have Benjamin Rush, famous physician in Philadelphia, who gets together with his friend Benjamin Franklin, and they go to the legislature in Pennsylvania and say, "We need some money for a hospital to take care of people because Doctor Rush says because that's the right thing for us to do, and we know how to treat people, and we should have a place where we can do it." And Franklin, they tag team this one in the legislature, and Franklin comes in and says, "Yeah, and besides, they are a terror to their neighbors." So he's on once it's good cop, bad cop. The doctor's saying we really ought to be compassionate and take care of people, and Franklin's saying, "Yeah," and they scare the hell out of people. So we got to get them off the streets. So the argument that there is a social benefit as well as a protective role for government in building institutions and funding institutions is there from the very beginning, in the colonies, really. And then you've got an institution where you can send people. Well, the institutions turned out to be mostly for people who were seriously mentally ill, suffering from what we would today consider psychotic disorders, unable to take care of themselves, perhaps suicidal. Um, and so, what do we do with those are the most seriously ill people? But what do we do with people who are not seriously ill, but just are unable to function? The people that back then, maybe in the 19th century, they might have called feeble-minded, harmless perhaps, but unable to take care of themselves. What do we do with them? Well, if we put them in those institutions, then they're going to be preyed upon by those other people. Some of whom are quite violent, and that's not good. And besides, it's very expensive to do that. And if we put them in jail, it's even worse. Even if we're doing it for all right reasons to protect them, it's still a terrible place to be. They're in there with criminals. So why don't we have a special institution? A special institution is designed specifically to take care of people who are not able to function in society because of their mental limitations. And that's where places like the Virginia colony comes in. It's opened. Um, it's opened for people with cognitive disorders, and then eventually for people called cognitive disorder. Excuse me. I mean seizure disorders, uh, like epilepsy. Something that couldn't be treated at that time is greatly misunderstood. Something which now we treat as a matter of course, but back then not so. So we people like people who have epilepsy, but we also have people who are cognitively disabled, and that's a place where they can be taken care of. So at the very beginning, this is a very philanthropic notion. Those places, though, tended to be, and this is by plan, out in the country. There was a kind of magical size. You had to be over a certain size to take advantage of the economies of scale, to have enough people to work, to have enough people to take care of, to function with staff, maybe to have a farm, maybe to have small manufacturing units, things that will make this little city in the country self-supporting. And so the little places like this got bigger and bigger because there were so many people who needed that kind of care. And also because those places were used not just to send people who had perhaps cognitive deficits, but also what others thought were moral deficits. And that's where we come to people like Carrie Buck, who's somebody who's thought to be feeble minded, but really feebly inhibited, unable to control herself sexually. So, this is a case very, very much about sex. And I say this all the time, and people usually laugh, but it's a good way to remember what the motives are in a case like this. The first motive is people like Carrie Buck who are getting pregnant because they're having sex, but they're not going to be able to take care of their kids because they're not married. And maybe they'll have more of them. And what happens then? Well, then somebody else has to pay for them. And the somebody else is going to be a charity or more likely the state because these children will end up in homes for orphans or foundling homes. They will end up on the streets. They will end up, through no fault of their own, being the victims of a cruel society. And the nicest thing we could do for them, say the reformers, is to make sure that they don't get born. And that'll do two things. It will take away the cost of this unruly sexuality in people like Carrie Buck, they say, and it'll also save us money because we won't have to pay for those children. No children of the feeble-minded, no need for facilities for the feeble-minded. Our taxes will go down. These are very explicit promises that are made, and it's easy to document that this is the way that they describe the process. We want to get rid of people who are unable to control themselves sexually, unable to control themselves because they drink or do drugs, unable to control themselves, and so they commit crimes. We want to get rid of those people by making sure that they're not born, and that's why we have places like Lynchburg, which allow us to treat people, but also to sterilize people. So that's the motive behind both institution building and the law.
So the your social failure and moral failure becomes potentially my financial burden.
Exactly.
Honestly, that doesn't sound that historical to me.
It does not at all.
No, it's a very old argument. Was made before, certainly was made before the people in Virginia decided to build a colony. You can go back. Um, I mean, the easy study is to go back to Elizabethan England and look at the arguments about the poor laws and how they work, and how people, if you give them too much corn, they just have more children. And the word burden is used constantly.
Mhm.
So it is about the burden to everybody else of someone else's missteps. That would be the kind way they would put it.
Right. It definitely has a Dickensian feel
Oh
for
yeah,
sure.
yeah,
Yeah.
yeah.
So could you tell us a little bit about the gentleman who ran the Virginia colony at the time? Uh, we've read your book, and this guy stands out
Hmm.
for sure. Tell us a little bit about, I believe the gentleman's name is it Dr. Pretty?
Yes, Dr. Albert Pritty. Dr. Pritty is an unusual and fascinating character from a number of different directions. Um, he is a physician. Um, he also spends some time in the legislature, so he has a political side. He ends up being appointed to oversee what becomes a very large institution, a small city, 4 or 5 thousand people. Um, it's important to remember, and this is something that's also documented, that when those institutions that I just described were growing in America, it was pretty much understood that the superintendents, who were always then, they were always physicians, were kind of like little kings. They weren't the mayor, but they were overseeing a town just like a mayor would. But unlike a mayor, they didn't have any citizens to respond to or to be accountable to. They had to be responsible to the government for how much money they spent. But they had the potential for being little dictators. And this is the way that they were written about within the medical press at the time. That you, if you ran an institution like that, you had almost literally the power of life and death over the people who were there. Now, does that mean they were all monsters? No. We have lots and lots of examples of particularly noteworthy people who ran large institutions, and um, we also have plenty of examples of people in those roles who were abusive. Um, Dr. Pretty, it turns out, his patients would have described him as both of those things. Some of his patients certainly said and thought he was abusive. Other patients thought he was a saint.
Hmm.
There was a clock that was made that used to sit in what is now the Virginia Colony grounds, the Central Virginia Training School. It was called when it was closed. Um, there was a clock in the administrative building there that was made by one of the patients and given as a gift to Doctors Pretty and Dr. Bell. Um, and there were all kinds of letters written by families to those doctors praising their work and how well they had been able to take care of family members of others. So you have people in there, you have people with two different perspectives on the men, and they are all men that we're talking about here, who were the doctors in this case. Dr. Pretty had a motive um, for sterilizing women and getting a law that would grant him explicitly the right to do that because he'd already been doing it. He started doing it in the middle of the around 1915 or so. Um, he sterilized several dozen people. One of them turned around and the family took him to court. He was very angry. He had no desire to make the trip all the way to Richmond, Virginia, um, so that he could be questioned in court by a bunch of hostile lawyers. He was embarrassed, he was insulted, and he was sure he didn't want to do it again. And so he went to his lawyer and said, "We need a law that will allow me to do this." In fact, that's what the judge told him. He didn't lose the case, but the judge said, "You got to quit this surgery out until you get specific directions in the law that says you can do that." And so he goes to his attorney and says, "I want the law. We want to get the law changed." And that's when the machinery starts to collect information about what kind of law they might need and where they might get it, and that's where what they get directly into the national eugenics movement, because the eugenics movement had, for by that time, more than 2 decades, been talking about the possibilities and the realities of writing laws that would allow people to be sterilized in state institutions. And there were more than a dozen states that already had these laws before Virginia. So Dr. Pretty knew it could be done. He told his lawyer, "Let's get it done here, because I don't want to go back to court again." And so that's where the sterilization statute comes from in Virginia. It is a statute that allowed Dr. Pretty to do exactly what he'd already been doing. But in this case, he was given immunity. They couldn't sue him if he did it to them.
And so, why was it important for the colony and for Pretty to test this law?
Well, Dr. Pretty was really happy that when it passed, and he actually went to his lawyer and said, "Great, we got the law now. Let's just start him up. Let's start sterilizing." And his lawyer said, "No, no, no, wait just a second. You're getting ahead of yourself. The we've got the General Assembly that passed the law, and the governor signed it, and this is 1924, and it's on the books, but it can still be challenged. And if it's challenged, you sterilize somebody and they go to court, then you might lose. The law might be overturned. The law might be found to be unconstitutional, and then you're back where you started. And we don't want that. So we really need a case that will go all the way through the court system until we get a validation that this law meets the standards both of the state of Virginia's constitution as well as the United States Constitution. And so that's what happens. They have a case. The case is appealed to the state Supreme Court. They say yes, it's okay here, and then the last stop is at the court in Washington D.C., where the federal Constitution is interpreted as allowing this procedure.
Could you walk us through the we just went through all the way to the Supreme Court there, but the first hearing is at the colony. Could you describe that hearing a little bit? The who was involved and what the arguments were?
Yeah. Well, there's a whole series of legal steps, and I think that um, the first one that Carrie Buck is involved in is at the colony, but actually is one before that. The very first one is a meeting with her foster parents who go to a magistrate, and they meet two doctors, and they swear out commitment papers, and so that's a kind of mini hearing itself. And they fill out those papers, and they're asked a series of questions about, what's going on here. Why do you want this person sent to the colony? Are they feeble-minded? Are they a moral delinquent? Are they epileptic? What reason do you have for getting them in? And so the foster parents at that hearing essentially say that Carrie is epileptic, and that she's feeble-minded, and that they've known this for many years because they've known her since she was a child, and she just had a baby and she's not married, so she must be a moral delinquent. What kind of girl would do that? So that's the step that gets her to the colony. The commitment hearing is the first step. And there's a whole set of law that allows that step. The second one, the second hearing, the hearing that Carrie attends, is before the board of directors of the colony, because the law was written to say that Dr. Pretty couldn't just do this on his own. There had to be a vote of the directors of the institution, which met every few months, and they would come up with a list of people and say, these are the people that need to be sterilized. Here are the people who have been appointed to represent them, their guardians, and this is the claim that's made of them. They fit the characteristics that are laid out in the law. And the law said that someone who could be sterilized was socially inadequate. And that might include everything from criminality to poverty to uncontrolled sexual impulses. So they argue at that hearing that Carrie Buck is one of those people, that she's limited in her ability to think through things, that she's limited in her ability to control herself, that she's a moral delinquent because she's having sex and she's not married. And the evidence, of course, is this child. And there's something also, her mother is already at the facility. So we've got a mother there, we've got now Carrie there, and there's some evidence that the daughter, who is not there, has been left behind, also has some kind of what they call a defect. So we've got this whole family of people. That's what the law was written to address. And so the board of the hospital, or excuse me, the board of the colony stamps that one and says yes, um, go ahead with the operation. And then the next part of the law allows for the person who would be subject to surgery to challenge that decision. They have to go to court to challenge that decision. And the machinery for that, of course, involves having lawyers. There's a person who's named as Carrie's next friend. That's a legal term. Basically, their guardian ad litem, their guardian for the purposes of the lawsuit, and they go with them to speak on their behalf. Carrie was underage, so you would have, the same way that a parent would speak for a child. So she's there, she's got her guardian, and they appoint a lawyer um, who is going to be paid by the state to take this case to challenge the law. So the first hearing results in an order for sterilization. The next stop is at the local courthouse in Amherst County, Virginia. And that's where the second part of the story begins and the trial occurs.
And how did her defense counter the colony's case?
Well, that's one of the more distressing parts of this story because her defense really never does challenge um, the evidence that's put on by the colony. The trial lasts about 4 or 5 hours. Um, the state puts on about 10 witnesses, school teachers who knew of the Buck family, neighbors, one person who I believe was supposed to have known a half brother of hers by some other man. Um, a whole The doctors there at the colony, a whole bunch of people who are saying yes, she is socially inadequate for all the reasons they said at the hearing. She's a member, says Dr. Pretty in his own written statement, of the poor white trash of the South. So all the evidence that's put on by the state points towards having her sterilized. Her defense doesn't really question the factual basis of what the state is doing. It doesn't really question whether or not Carrie, for example, could read and write, which she could and did, that she'd gone to school, which she could and did, that she performed reasonably well there, that she maybe wasn't such a bad person. She belonged to two different church choirs, must have had a nice voice, but we never hear that at the trial. We don't hear any of that. Her teachers are not called, her grades are not introduced, uh, her choir masters are not called as witnesses. No one speaks on her behalf. No witnesses, no evidence presented for her, which to I think most people would seem strange. Um, to those of us who are lawyers, it seemed very strange. And after doing research on her life, it seemed not just strange, but intentionally maleficent, because we do know that they were just as aware of her schooling and her social life and her industriousness as a worker, for that matter. That and yet none of that is presented in the at the trial. So this is a case which I have concluded was set up from the very beginning for Carrie to lose.
And so I have kind of a dumb question, but Jarrett and I aren't lawyers. Um, are
Absolutely not.
are so isn't the lawyer supposed to try or to if they have all this evidence or information and they have it within them to put on a case, aren't they shouldn't they aren't they supposed to do that? Aren't Isn't that what being a lawyer is? I don't know, as a layperson.
Absolutely. Um, Without any question, that's the lawyer's job. The lawyer's job who is to defend the interests and the rights of the client as zealously as possible. And there's an old saying which everybody's heard, which says if you're in court and the facts are on your side, you pound the facts, and if the law is on your side, you pound the law, and if neither the facts or the law are on your side, you pound the table. Well, in this case, we got no pounding. We had a challenge of the law on very broad constitutional grounds, and that's very clear when you read the transcript. Um, the first stop should have been facts. Should have been, who is this person? What is this theory that says that people inherit all the bad habits and the bad propensities of their parents and grandparents? Do we have anybody who would argue with that theory? We've got experts for the state who come and said this theory makes sense. Where are the people on the other side? Who would come and speak against it? As it turns out, there are lots of people available to speak against it, and they are writing articles and writing books and speaking publicly about this, and they're famous people. They are just as qualified and just as noteworthy as the people who speak, actually more so than the people who speak on behalf of the state of Virginia in this case, and yet they're nowhere to be found. So even the questions of the validity of the law as a scientific matter, forgetting all of the facts which I've already recited, which would have been supportive of Carrie, even if you didn't bring up those facts, which you should have, you still would have a lot of reason to attack the law itself. And Irving Whitehead, who for my money is the real villain of the piece, um, Irving Whitehead doesn't do that. He's supposed to be representing Carrie Buck. He makes only the broadest kind of statements about the problems that might exist with the law. He does no investigation. He apparently doesn't even interview his client. There's no evidence that he did. And so he doesn't know any of this stuff, or he certainly doesn't bring it up. And yet he's paid quite well. This is not a charity case. He's paid for his work. In fact, ends up being paid more than the lawyer for the state is paid. So you're right. You don't have to be a lawyer to realize that when your lawyer is not defending you, you're getting a bum deal.
So this is a gentleman who's paid by the state, right?
Mhm.
So both lawyers were paid by the state,
Correct.
one to represent the state and one to be antagonist to the state.
Right.
Were there anybody was there anybody watching this trial who at at the time who was commenting on what seems like an obvious conflict of interest? Was there a good deal of publicity about this?
No. Um, I think that any person in this country, in almost any town, can walk into a courtroom. You don't even have to be a citizen. You just walk into the courtroom. There are courts in every town in this country, and the one thing you'll find is um, relatively few people sitting around watching. You'll find people who are bringing lawsuits for every possible kind of thing. They get bit by the neighbor's dog. They get run over by the neighbor's truck. They lost their house in foreclosure. All kinds of terrible things that happen to people, and they may be suing, to get something back or to get money, or it may be a criminal case in which they're accused of doing something. And in most of those circumstances, there's not a lot of spectators. The only spectators may be somebody else who's waiting to get their turn in the court. So it's just not a normal thing that you have media coverage of every little bitty case. Now, here is a poor girl from a small town in Virginia going to an even smaller town where she's put on trial. Um, Nobody knew about this. Nobody knew that this case was going anywhere. It's only after it goes to the trial and then ultimately goes to the state appellate court that anybody learns about it in the newspapers. So questioning the circumstances of the lawyers at that point was just not likely to occur. But a bigger point is it shouldn't matter. It normally we would normally raise the question that you're raising, which wait a minute, both sides being paid by the same people. Is there something strange going on there? Well, let me give you an example. We have legal aid bureaus in all the states. We have lawyers who volunteer, lawyers who are paid out of public funds to do exactly what we're describing. So I could go to court in Virginia, um, and I could be paid as a lawyer to represent a client, and the pay might come out of the state. My obligation, nevertheless, is not to the state, it's to that individual. My oath of office is that I will uphold the laws and represent the people that I'm supposed to represent, regardless of who's paying for it. So the payment certainly raises a question, but it doesn't by itself um, prove anything. And there are lots of other cases in lots of other states at the same time in which this was the arrangement, and yet the lawyers did a good job.
Mhm. Hmm.
I had completely forgotten about the whole if you cannot afford a lawyer will be appointed for you thing.
Yeah.
And so, okay, so just to put it very mildly, her lawyer wasn't really trying then. So then, how did this case get to the Supreme Court? Was this more of the fix, so to speak, and the test?
Well, it was, as I said earlier, it was intended to go as far as it could. Supreme Court would have been the last stop, no matter what. But the people who wrote the law, Aubrey Strode, the lawyer who wrote the law and who then argued it for the colony as representative of Dr. Pretty, he he told them that we really would like this to go all the way to the Supreme Court because then there won't be any questions of whether it's valid. And so that's what that he definitely wanted that to happen. Um, I don't think there's any. Um, I no longer have any doubts that the people who were involved, well, the lawyers who were involved in this case knew what was going on. Um, First time I read this case transcript, I was a graduate student, and I scribbled all over it. Like, how did this happen? There are all these questions. You don't have to watch too much TV law to realize that cross examination is a real thing. And when someone makes a broad statement that can't be supported by facts, that they get questioned. And yet, here's some doctors getting up and saying this woman is feeble-minded and it runs in her family. And there's these are the law. This is the law of Mendel and heredity, and this is how it works. And nobody questions how certain he is about that, or whether he was ever wrong about that, or whether there are any other cases like this. Turns out there weren't. Harry Laughlin, the man who also testifies in the case, it was the only one they'd ever had. 3 generations of people in the same family, the perfect case. So it wasn't like this happened every day. And yet Whitehead never asked that question. Um, I've been convinced for a long time that Whitehead knew that what he was doing was wrong. I've also been convinced because I wrote a biography of Aubrey Strode and I went through his papers in great detail, that he was a real lawyer and he was a good lawyer in terms of his technical prowess. And he knew what good cross examination was, and this wasn't it. The fact that one of his best friends from childhood was the guy on the other side. Um, Again, in a small town, it's not unusual that you know the lawyers and they may be friends, but it is unusual that you have this whole combination of conflicts. So it's a friend of yours, they're paid by the same people, and the one guy's not doing a job. Um, so I think that to say the fix was in is not overstating the case.
It's a little frightening that I'm trying to like exaggerate, and you're like, no, that's accurate.
Call a spade, I guess. So we get
Well,
to this.
it's easy to criticize, a litigation strategy after the fact. Once somebody loses, you say, "Oh, I would have done it differently." But in this case, we've got the records. We've also got the records of people like Whitehead, and realize that he is a man who is supportive of sterilization. At the time which Dr. Pretty is being sued for sterilizing people because there's no law that allows it, Irving Whitehead is on the board of directors of the same institution. And what does he say? He votes in favor of sterilization.
Mm.
After Dr. Pretty is told in court, don't do this until you get the law changed, Irving Whitehead writes him a letter saying, the judge was wrong. He should have thrown this out. You did what you were supposed to do. That's exactly what we need. He was a very strong supporter of this process and even voted for it. So that's the third thing. He's friends with Strode. He's paid by the state. He doesn't present a defense, and he even supports the process itself, and was a member of the board of the institution where it's happening. And the last piece is after it's over with, after the judge in the trial court says, "Yep, Carrie Buck, you lose. State of Virginia, you win. Go ahead with sterilization." Whitehead then goes and reports to the board of directors of the state hospitals, which is a group that met every several months of all the large institutions. And he goes and reports, even though he's the losing party, he goes and reports to them, and it says in the minutes. And Mr. Whitehead appeared and told us that the state won the case uh, against Dr. Pretty, and he told us that this is the best possible result. And as we hope, this case is likely to go all the way to the Supreme Court. So he says it. He says this
Yeah.
was the best possible result. He losing is the best possible result. And that kind of convinces me that he's, it's in the bag.
Yeah. Gentlemen, I have lost. Mission accomplished.
Exactly.
Wow. So this case, this happens this is an appeal. And now how does it eventually wind its way up to the Supreme Court? Like Carrie's it doesn't sound like Carrie is really even a participant in this process at this point.
No, it's a typical case in the sense that once the trial is over, the the person who brought the case, for that matter, the parties, both parties, don't really have any involvement. Now, if you're a sophisticated person and your lawyer involves you in the process, they might say, "Well, we're going to write a brief to the Court of Appeals, the Supreme Court of Virginia. We're going to write a brief. Do you want to see it?" Maybe they would do that. They wouldn't do that for most people. They would just say, "We're going to file papers and appeal," and that it would go up. No appearance by the client at all. I mean, most appellate arguments are made with the client is maybe in a different city. And anybody who's ever argued one will tell you, again, you're usually in an empty room. I've done this. You're in a room, other lawyers, some judges in robes, but it's not like there's a whole crowd of people there, and your client is rarely there. So, sophisticated corporate clients might, send their own people there, but most people don't go to those. So again, we're really dealing with a case that's on paper at that point. The judges who are making the decision at the appellate level are looking at records. They're not questioning people. That's already been done. They're looking at the transcript of what happened. If there's evidence that's been introduced, letters, things like that, they look at that. If there's a law that's being challenged, they obviously have to look at that. But it's not about talking to the people who were involved in the event. So the Supreme Court of Virginia reaches the same conclusion, says, yes, this is constitutional under the state. And so the next step is to appeal that decision, which Irving Whitehead does, to the United States Supreme Court. Same process goes on. Papers filed in the court, an application to be heard. It's granted. That's in October of 1926. And then they set the case for argument, and it's argued. And then in May the 2nd of 27, the justices issue their opinion. And the opinion, of course, is the famous line from Oliver Wendell Holmes, which describes the Buck family as a family that is hereditarily defective and a family that's going to produce more of the same kinds of people, like Carrie Buck, and a mother, a daughter, and a granddaughter, all of them apparently feeble-minded. And Justice Oliver Wendell Holmes, then, who's given the job of writing the opinion in this case for the court, an almost unanimous court, eight justices in favor, says it's better for all the world if people like this, rather than being starving to death because they're imbeciles or dying because they're criminals, it's better for them not to be born at all. And he underlines the three generations and says 3 generations of imbeciles are enough. So that's the result out of the Supreme Court. Again, Carrie Buck is not there. Her family's not there. The only people there are the lawyers in the case.
So, another silly question. So if her lawyer didn't try, isn't trying, and you get to the Supreme Court and it's all basically a record review, but like the record that exists is crap. It
Mhm.
sounds to me like if he wasn't doing, if he wasn't trying and whatever down at the trial kind of part where she was there next to him and they had all these witnesses, it goes up to the Supreme Court. And so I guess the Supreme Court only has like half the story. Is that what this means?
Yeah, the appellate courts do not have the luxury of saying, "Gee, this is funny. Why don't we go ask some more questions?" They are charged with deciding on a record. They look at the record, lawyers on both sides, you know, good, bad, indifferent, and there are plenty of all sorts, good, bad, and indifferent. And they look at the record and say, what evidence is here? Is there enough evidence to support, if it's a criminal case, is enough evidence to support the charges? If it's a civil case, which side has presented the most evidence that will, win the case? And in this case, all the evidence goes for the state. There's no evidence on the other side, so it's not a hard call on the evidence grounds. The hard call is whether or not this statute, which allows the government to operate on people whom it thinks shouldn't have children, that that government is does the government have the power to do that? Does the Constitution somehow grant governments the right to operate on people because they think they should for the benefit of the rest of society? So that's the big question. And the court at that time says yes. Holmes uses an old line, and it's repeated in lots of places. Most of the Holmes opinion is not new. It is the language that he uses is cribbed from a number of different writers. But this one line he talks about is an old analogy of, well, we send people off to war, so obviously we can send people to be killed. If we can kill them, we ought to be able to operate on them. Well, not exactly. Those things don't necessarily follow one from the other, but that's the argument that he makes. Uh, we have seen more than once, he said, where the society may call upon the best men for their lives. And of course, he's talking about himself. He's talking about being in the Civil War. He's 20 years old. He goes off and goes to a battle, gets shot. Family comes and picks him up, patches him up, sends him back. He gets shot again. Um,
Jeez.
he doesn't want to go back. He goes back to Boston. He's almost dead. They find him, on the side of the battlefield. His father's a famous physician, so he knows a little bit about, what people endure with wounds like that. Takes him home, patches him up, and shames him into going back again. He goes back the third time, and he gets shot again. So when he writes the opinion in the Buck case, he's really talking about himself, his generation, when he never quite got over, and it's understandable. He said we were touched by fire, and he meant exactly that. He was shot 3 times. So if I can get shot 3 times, we can operate on this girl in Virginia. That was basically the logic. And he is supported by votes from everyone else on the court, including Chief Justice Taft, who by then had been president of the United States and Chief Justice of the Supreme Court. People like Brandeis, famous justice, um, a number of others of less repute, but the one who stands out is the one who dissented, and that was a man named Pierce Butler. And Butler does not leave an opinion, so there's no written record, and as far as I've been able to find, and for that matter, anybody else, he never spoke about publicly what his reasoning was. There's a lot of speculation that because he was a Catholic, he was against this, and that may have been the point. Holmes thought that was the point, and said at one point he thought, he was going to go with the church. Um, and the Roman Catholic Church had been pretty consistently against operations like this, although it wasn't until the 1930s that there was an actual official statement from Rome on this. So anyway, that's Butler. He was the dissenter, and so it was an 8-1 decision, and the 8 carried the day. You ask about Whitehead and his arguments and what happened at that point. Whitehead was in a really clumsy situation then, because it turned out that after the state decision at, in Richmond by the Virginia Supreme Court, after that opinion was issued, there was some press. And there were some groups around the country who were watching these cases, and one of them was a Roman Catholic men's group, and they had been monitoring cases like this. They had some very able lawyers on their in their ranks, and they wrote a letter to Whitehead and said, "Here's a bunch of things you might have said. We will be happy to help you file a petition for rehearing." So Whitehead was kind of embarrassed because they sent a very well done draft and said, "Here are some things you might raise. Here are ways you might focus your argument a little bit differently." Um, and you don't have to even give us credit. Just do it. And Whitehead said, "Well, okay." He took their work. Um, he ended up filing something which he was paid for. They were not. He changed it a little bit though because he was embarrassed that they had raised some questions that he should have raised at the trial and did not. And he thought that that was going to be, that was going to look really bad if he suddenly brought them up on appeal. First of all, they probably wouldn't listen to him. They would have said, "You lost your chance," and it would have been an embarrassment for him to admit that he should have done it anyway. So it would have been ineffectual as well as embarrassing. So they filed the petition for rehearing, which meant that there was a delay in the actual sterilization operation. But come October, when the court met again for the first time, they dismissed that petition, and
Mm.
Carrie's sterilization actually occurred in October of 1927.
I really want to get into the impact of this decision, but before I get there, just really quick, going back to Butler, there was a note in your book that Nikki and I both sort of independently kind of circled about, I believe it was Taft had maybe put some pressure on dissents not being written. You can dissent, but don't explain yourself.
Well,
Do you have any insight into
this
any
is
further
this is
insight into
less
that?
this is less a rule than a convention or a habit. And um, I don't think Taft had any particular hand in it. Taft was the Chief Justice, and so he could have conversations about anything he wanted with the rest of the justices. But when I attempted to do an analysis of how likely it was that someone would file a dissent, the librarians at the Supreme Court library there in Washington had already done that sort of thing, and they knew what the statistics were, and so they gave them to me and said, "Here, in this period, it was very unusual for people to file um, written dissents, and relatively small number of actual dissents. That the number of dissents that occurred in cases like this was probably relatively small. The number of written dissents was even smaller. So I didn't put any particular note in the fact that the dissent wasn't written. It was also Justice Blackmun who became famous years later for writing the Roe versus Wade decision. Um, we had a brief correspondence about this a long time ago, and he said that when he was a lad, he said, "When I was young, I would go to him, and he was a young lawyer. He would go to banquets, and sometimes Butler was still around, and it was a running joke for him to be introduced at the kind of after dinner speech, and they would say, as Justice Holmes said, um, 3 generations of imbeciles are enough, but Justice Butler dissents," and then everybody would laugh.
So it was a bit of a norm, not unusual, and there's nothing about it to read into, you know, his thinking. Even, wasn't like, I don't want to write something. I'm not scared. I'm scared of writing something. It's just there
No,
was a
no,
norm at the time,
no.
and
I,
we
I
as
don't.
historians have to just
Live with it.
live with it. That we don't know what he was
Yeah, well,
thinking.
we don't know. I think that there was apparently some debate among the justices about the language that Holmes used. Holmes says this in a letter. He said that they kind of got on my back because they said my language was too harsh, but come on, it's my style, it's my thing. I'm the guy who writes these great opinions. Come on. I mean, he was 80 something years old then.
Mhm.
He was not lacking in confidence. He was on the cover of Time magazine. I mean, he was everybody's idea of a judge. So, uh, but some of his colleagues didn't particularly like the fact that he wrote expansive opinions, sweeping opinions, made phrases that people remembered, and either because they were resentful of him or jealous of him or just wish he'd shut up, that they didn't like what he had said, and so he maybe did some small edits. Taft may have suggested to him that he change the language, which is what happens in opinion writing all the time. In order to get the votes, you have to write it so the other people will agree with it. So that's the
Sure.
you know you, you, the rule of five is still the rule in the Supreme Court. If you don't get five votes, you lose.
Mhm.
So he knew that he had the five votes. Taft may have very well said, tone it down a little bit. Well, he didn't tone it down very much, as you can see.
Yeah.
It's a shame because, as from a nerdy kind of a standpoint, reading the dissents is some of my favorite stuff. Like either there's more information or there's nuance or there's just drama. Um, where it would have been really nice to kind of see, well, in this case it was 8-1, if
Yeah.
somebody, you know, had some big stance or was it like a minor quibble or
Yeah.
what have you.
No, there were grounds. I mean, there were grounds in other state cases that laws like this were overturned. The thing that Strode benefited from in writing the law in Virginia was there had been, as I said, more than well, the first law was written in Indiana, the first successful law in Indiana in 1907, and there were another dozen, and there were challenges along the way, so they knew what the challenges would be. So they wrote the law. Strode wrote the law with all of these things in mind. And this is the way you do it. If you're a good lawyer, you say, okay, what are the likely objections? Let's take care of those in advance. Oh,
Mhm.
they say this is something we're only doing to men. Well, we'll do it to men and women. They say this is something that we're only doing to people based on their race. So we'll do it to everybody. They say this is a law that applies unequally because this person didn't have a lawyer. We'll give them a lawyer. They didn't get to testify. We'll let them testify. So all of the possible objections that were procedural were taken care of in the way the statute was written, and they followed those religiously. And if you read Dr. Pretty's correspondence, which I have, he was insistent that they follow those to the letter, precisely because he'd been dragged into court before because he didn't follow the rules. So yeah, all of that was taken care of. Um, and the statute, at least the first time it was applied with meticulous precision.
Hmm.
So, the Supreme Court has its ruling. It's 8-1. Holmes has this fiery but short-ish for him opinion, and now this Virginia law has the blessing of the highest court in the land, from the
Mhm.
federal courts. Is there an explosion of eugenical law in the United States following this? Is it some
There,
places or others?
there were about 14 laws at the time the Virginia law was passed. By the time the last state passed a sterilization law like this, based on the theory of eugenics and hereditary defects going down generation to generation, was 1937, and that state was Georgia. So that was the 32nd law that was passed. So there are, you do the math, 20 some odd laws passed between the time of the Buck case and this. Meanwhile, across the border in Canada, um, British Columbia passes a law. So sterilizations in Alberta, quite a few. And there are sterilizations, I believe, in Ontario. I'd have to go back and look that one up again. I've forgotten. But in any event, there are at least three places in Canada where there are also sterilizations. and they rely on the example of Buck. They don't have to rely on it as a matter of law, but it's an international example that's used. So to say, did it have any effect? Well, yeah, I think so. Certainly did. Um, and the most obvious and the most dramatic, of course, is that in 1934, when Hitler comes to power, 1933, among the very first laws that's passed um, in Germany is the sterilization law, more expansive even than the one in Virginia, but one which, according to the Germans, looked to laws like the one in Indiana, the one in California, and the one in Virginia as their basis. They set up a series of courts, eugenics courts in Germany, and when those courts are challenged at the Nuremberg tribunals after the Second World War, when doctors are put on trial for the torture they were doing in the camps, in some cases involving people who were not citizens and who were essentially given chemicals or X-rays or some other experimental way of sterilizing them. Um, their response is to say in defense, oh, well, it's just the same thing they do in America. You're saying we can't sterilize people. That's what they do in America. We sterilized 400,000 Germans, and we sterilized another, whatever, you're saying 50, 60,000 people in the camps. That's what they did in America. And they introduced the case of Buck versus Bell as part of their defense. So I'd say the case had some reach.
Yeah. Not maybe not what we want to be known for.
I don't know. We aren't we supposed to, what is it, City on a Hill or whatever?
Yeah. Just don't look in the behind the curtain, I guess.
And I had to follow up, so on the one hand, we're kind of talking about this from, this was in the past and and this helped inspire the Nazis, but is it in the past? Have we, stopped stopped with the sterilization, with the involuntary sterilization?
Well, it's um, you have to make some distinctions about what kind of surgeries are going on or have stopped. The laws that were passed between 1907 and 1937, which are generally described as the eugenic sterilization laws, which focus on this notion of hereditary passing down of characteristics that are, you know, um, undesirable. Those laws have all been negated. Um, I think there may be one that's left that's pre that period, but it's a punitive one. It's not written the same way as the others are. In any event, the eugenics laws are all repealed now, even though the last sterilizations took place probably in the 1980s.
Oh, cool. Okay. So,
Yeesh.
The last one in Virginia was 1979, I believe. Other states have said there may have been some others in the 80s. So by the 80s, that part had stopped. There are still something like 16 states that allow for sterilization of someone for medical reasons, a person who cannot consent for themselves for medical reasons. We know that there are abuses under those statutes. The people are sterilized because the family wants to, and a doctor agrees to do it. We don't have records because this is not something done publicly. We occasionally have some judge who's decided that they're going to play doctor and declare that somebody needs to be sterilized before they get out of jail, or that they need to be sterilized and have their children taken from them, or any number of other things. And we see cases like that pop up periodically. They never quite have gone away. And then we've got other examples of kind of reproductive interventions that happen to people in prisons. Some 200 women in California prisons sterilized, as much as a decade ago. Um, we know that the same kind of thing was going on in immigration camps by ICE personnel or by people who were doctors who were working in ICE facilities. So yeah, there's still plenty of sterilization going on. Usually surreptitiously, or certainly not in the public eye. All of the, with the exception of the ones that are ordered by judges and are immediately challenged, we don't know about most of the other ones unless somebody's doing some serious digging.
I think the Equal Justice Initiative does some tracking, but I don't
Yeah.
know. I mean, they track a lot of different
Yeah.
injustices, so I don't
Yeah.
know if they have like a task force on that or anything.
Yeah.
So we've talked a lot about the case, some of the individuals who are involved. We have Whitehead, Strode, Pretty goes up to the Supreme Court. We've got Taft, Butler, Holmes. These are all the people of legend, in the historical record. But one person I feel like we've left out here is Carrie, the human being, the victim. I think it's fair to say the victim of of the case, of the movement. And uh, we think about some of these cases in 1920 seems like a really long time ago, but my understanding is you met Carrie Buck,
Yeah.
at least briefly. Like, this is not ancient history. So I was wondering if you could spend a moment and bring us up to date on Carrie, you know, post trial. Who was the human at the center of this case?
Okay. I think your timeline is really important. Chronology is worth looking at. No, it's May of 2025. November of 2024 was the centennial of the trial that we just talked about. Okay. So that means there are people alive today, not a whole lot of them, but some. I actually know one of them who were alive then.
Hmm.
So this is not ancient history. Anything that's happened within the life of somebody who's still with us is not ancient history. If you're 25, you may think anything that didn't happen more than 2 weeks ago was ancient history, but still, um, some of us who are old remember the period that all this stuff came from. So that's the first point. The centennial of the Buck case in the Supreme Court is only going to be 2 years from now. So 1927. And there will be a lot of people around then who were around in the late 1920s. So again, not exactly ancient history. As for Carrie Buck, um, I had the good fortune of finding her um, in 1983, just after Christmas. It was about a week after Christmas, as I recall. And I drove out. I was living in Charlottesville at the time at the University of Virginia, and I drove out to Waynesboro, where there's a little facility. It was called the District Home. It was basically a nursing home. And I had heard that um, that's where she was living. I had heard that she had been taken to the hospital several times because she'd been living in a little small cinder block building, uh, which I believe had running water, but I'm not sure that it had indoor plumbing. Um, and she was living there at, you know, as a charity, really, of the person who owned the property, she and her husband. Um, at that point, she'd been married to this man for about 25 years, I think. In any event, she was at the district home. I went to see her, and I really only had one goal, and that was to verify her perception of what had happened to her and my perception that she had been victimized, not because of some dreamt up problem that she had with her brain, the way she thought, um, and not because was an evil person, but because she was being condemned for having a child and not being married. And so I asked her a question that others had asked her before, which was, they did they take you there because of your baby Vivian? And she said yes. She said my she called him her boyfriend, my boyfriend. He forced himself on me. Um, so she essentially confirmed to me that she had been assaulted. Maybe today we would say date rape. I don't know. Um, it was her perception that she had been forced and then she had been abandoned. And as I write in the book, both of those things were crimes in Virginia at the time. Some other thing that Whitehead might have looked at if he were actually representing Carrie Buck, but he didn't. So the case turns not just on intentionally bad lawyering and on a malevolent dictator of a facility head, but also on the falsehood that Carrie was somehow promiscuous and and running the streets and getting pregnant without thought. But what really happened was that she had been assaulted. So Dr. Pretty gets his way, and Carrie gets sterilized. I we don't know very much about Carrie. Um, she had a hard life. She worked on farms. She worked taking care of other people's children. It's one of the great ironies because the argument was that people like Carrie Buck shouldn't have children because you can't take care of them, and yet she spent a great deal of her life raising other people's children. So clearly that was a lie, as was the claims that she was somehow promiscuous. Um, she never had much, but she seemed to keep a very strong sense of family. I think one of the saddest things about the story to me is reading Carrie's letters that she wrote. I published a series of these a couple of years ago that she wrote to the nurse and to Dr. Bell. Dr. Bell took over the case after Dr. Pretty died right after the trial. And so it became Buck versus Bell rather than Buck versus Pretty. Dr. Bell would write back and forth to patients who were out on parole, they called it. They were essentially placed with families for whom they worked for a pittance, $5 a month or something. And until they were able to prove that they were on the straight and narrow, they could be brought back to the colony. So she works for a time out in Southern Virginia, and then she says she wants to get married. And the doctor says, "Well, that's good. That'll be a stabilizing thing for you, and you can get married, and then we'll release you." And so she does. We have a photograph of her and her husband at that point. But we don't really know too much about her other than that. Other than she occasionally would write letters to her sister Doris, would occasionally write letters to the nurses and the doctors at the colony. And one of the last letters we have is an attempt to come and visit her mother. She has found her half brother, a man named Smith, Roy Smith, and they are going to come and visit. And she's obviously made a real effort as he lived in Charlottesville. Doris lived around Charlottesville. And Carrie turns out to be the glue in this family of trying to bring them all together again. And so they're going to go back to Lynchburg, where her mother still is at the colony. And she writes a letter saying, Mom will, we'll be there. We'll bring you something. She shows up, and unfortunately, her mother died a couple days before, and they didn't get in touch with her. And so she's met with the news that her mother's dead. And to me, that's one of the really painful parts of the story. Here's somebody trying to do all the right things, and she didn't get the memo. So that's what we know about Carrie. We don't know very much. Um, it would, I suppose, for better or worse, today, every person who talked to her would have a camera and a recorder in their pocket. I'm not sure that would be better. She at least got to have her dignity and privacy to a point and not being hounded. I'm not sure that would have benefited her any. So while I would have loved to have a 60-minute video of my time with Carrie Buck, I don't have that, and maybe it's better that I don't.
I have a couple more questions, but I do just want to stop here and say, thank you for providing context on Carrie. It's a painful, awful story, but she was a person who lived,
Mhm.
and Nikki and I. Well, you know it better than us as a legal scholar, but Nikki and I, as lay people going through court cases, you definitely feel a dehumanizing effect of how these arguments are made. And there's a human being on the other end of that. And,
Mhm.
I just want to stop and say I appreciate your work as a historian and a legal scholar and coming and providing some of that context, difficult as it is to hear.
I, you raised a question earlier, Nikki, about the issue of identity, and I think that it's very important. People often ask. One of the first questions people asked me was, "Was Carrie Buck black?" Um, and the answer is no, she was not. She grew up in a neighborhood, and this shows how poor the family was. She grew up in a mixed race neighborhood. So in 1920s Virginia, to live in a mixed race neighborhood was a marker of class for sure. Um, the opinion says, she's a white woman from Virginia, so that part's clear. People always ask what the breakdown was in terms of male and female, um, white, people of color, etc. And it's a hard question to answer because we're talking about a time frame that is so big. We're talking about sterilizations that really started around 1900. They officially start in laws passed in Indiana in 1909, 1907. Um, and from 1907 to 1937, we've got all these other laws are passed. And then we get sterilizations that go all the way to 1980. So almost 80 years of people being sterilized in 32 different places. So if you want to say who was sterilized, you have to say when and where. If you were in Virginia with Dr. Pretty, the odds were really high that you'd be a woman. The odds were even higher that you'd be white. Why? Because it was a segregated institution. That's why. Um, Go to 1939, or go to the Institution for African Americans in outside of Richmond or Petersburg, which was the colony there for the so-called feeble-minded. Those people were all black, but that colony doesn't open until late 1930s, and so you have to again, depends on where you are and what the time frame is. When you look at gender more generally over the whole time frame, it looks like there's something on the order of a few more, I don't know, 55% maybe women versus 45% men. In some cases, it's as high as 70% women in some states and fewer men. In some periods, it becomes almost all women. And so when you get up into the 1950s and 60s, states like Georgia, South Carolina, um, North Carolina to a certain extent, and Virginia still, is sterilizing black women who are on welfare. So the pattern that I set out earlier continues, right? It's about sex. You have to have sex to have the babies, right? It's about money. It's about not wanting to pay for other people's babies. So it's women on welfare. It turns out to be women who are black. And the same claims are made about them that were made about people like Carrie Buck, that they are unnecessarily sex crazed, that they are constitutionally immoral. That sort of language comes up in proposals all the way up to 1970. And I could show you people making these arguments. Doctors sending letters to the legislature saying we need to sterilize people. We need a new law to sterilize people on welfare. We need to sterilize. We need to criminalize this behavior and lock people up when they have children and they're not married. So that kind of story plays out over and over again.
I feel like, there's always, I in a lot of respects I feel like it's a lot of times it's kind of the same kind of stories or like, the line or the vibe, but you just kind of pick whatever marginalized community you want to sort of aim the barrel at.
I think you're right. I think that the habit that we describe as the eugenics movement is easy to encapsulate, and it's easy for people like me because we look for very specific dates. The law was passed on this day, it was repealed on that day, it was overturned on that day. So you can kind of tell a story that has a boundary on it. But the bigger story has no boundary, and the bigger story has to do with what do we do in this country to the people that we, as a group, dislike the most. Well, first of all, we have to identify who those people are. And whether you're in 1775 or you're in 2025, the story is relatively similar. We, when we are anxious and we are angry and we are concerned about our own welfare, we blame people who are poor. We blame people who are different. The difference might be color, it might be nationality, it might be religion, it certainly is race. So we identify people who are different. Some of those people, their behavior is different because they have disabilities. Some of those people have, for a variety of reasons, got caught up in the legal system. So maybe they've got criminal charges or criminal convictions. So if we take the list of people that the eugenicists wanted to sterilize, they're the same list of people that we blame everything on every time there's a crisis. And you can go back to 1920s and see it. You can go back last year and see it. You can go back into the 19th or the 18th century and see the same thing. It's our anxiety about who's running things, who is getting to be too big, who is getting to be too powerful. We got to go get rid of those immigrants, get rid of those people who don't look like us, whoever us are. And the us, usually speaking, are usually white Americans. And as often as not, white American males. So I think that the what I call the demographic anxiety is what explains a lot of what people want to say is a piece of the eugenics movement. It is certainly what the eugenics movement was about. Sometimes it focused dramatically on race, at other times it didn't. Sometimes it focused dramatically on gender, at other times it didn't. Sometimes it focused on immigrants or people speaking other languages, etc. So sometimes it focused on criminals and incarceration a lot. At the beginning, it did. So all that stuff is a constant, and it's a constant throughout American history. What eugenics does is give us a word and a kind of theory that we can use to make it make sense so that it's validated. And then after a century, we go back and say, wow, was that terrible? And others people say, no, it wasn't terrible at all. So I think if you listen closely, you realize that many people think that was a good thing. In my experience, speaking about this stuff for going on 40 odd years, there's always somebody in the comments who said, those pointy-headed college professors, they don't think we should do anything. He's completely wrong. We should still be sterilizing people.
That's unsettling.
At the same time, it's not surprising. I mean,
Well, it's
there
true.
are so many things that have been said. When you were describing, oh, back then, this, that, or the other was an issue, and I'm like, still is. And, in some respects, especially when you're talking about demographic anxiety, I mean, maybe eugenics was the dress we put on it then, but that stuff is still
Yeah.
here now.
Alive and kicking.
Yeah. We're at recording right now. We are 4 days past the 5-year anniversary of George Floyd.
Mm-hmm.
The Eric Garner, the government has had a history of putting its hands on bodies.
Yeah.
Some bodies, specific bodies at specific times, to your point. Maybe some more than others and more obviously than others.
Yeah.
I wonder, I remember, I want to say about 10 years ago, reading an article about North Carolina doing reparations of sorts for women who had been sterilized.
Mm-hmm.
in the, I want to say like the 60s or the 70s. And that was the first time, and I have a degree in history, so this is a sad thing to say out loud, uh, but that was the first time that I had become aware that we sterilized in the
Hmm.
United States. And again, someone who's studied history, uh, is I consider myself a voracious reader of history, and to have such a what feels now like such a very large blind spot, I think maybe the average I wonder if the average American knows that that happened. In the same way that I wonder if the average American knows that Japanese internment was an absolutely terrible, horrible thing, but it wasn't just the Japanese who got interned. But it's not the story that's told because the Japanese internment was so much larger, and they also went through and they got reparations.
Yeah.
But like Crystal City in Texas was for Italian. Well, I don't want to get this right. It was for Germans, absolutely, and I believe for Italians,
Hmm. Yeah.
citizens and immigrants.
Yeah. I had a number of friends in California who had been moved from coastal towns like Monterey into the Central Valley of California because they were Italian.
Yeah,
Yeah.
and the only reason I know that is a family member was like, "Hey, here's a book on a thing that you might not know," and they were
Yeah.
right. I didn't
Yeah.
know it,
Yeah.
Yeah.
and so yeah, and I wonder if the lack of visibility is empowering for the people who use it as a cudgel.
Yeah. I don't know. I think that I've said more than a few times that when people get angry because you talk about these unpleasant things, and they say you shouldn't be raising these issues. That history is not some greeting card that you get from the past. It
Mhm.
tells you only wonderful stuff. Um, if it's anything at all, it's a relatively straightforward, eyes wide open look at the way people behave, the good, the bad, and the ugly. And this particular chapter happens to be mostly ugly.
It's so interesting that people take the stance of, digging up old things and maybe taking a position that it's harmful in some way, just given that when we think about, for instance, trauma, and this is occurring at the individual level and also at the community, family, group level, one of the methods of healing is actually that storytelling. And first of all, providing your account, but then also making it visible, perhaps as a way to get accountability, but also as a way to just not have it locked up, inside
Right.
anymore.
Yeah.
And it's been sort of identified as as once again as a form of healing. And
Yeah.
so I just think it's so curious to take a stance of, no, we can't, learn about or discuss or,
Yeah.
that sort of thing.
Dr. Lombardo, thank you so much for your time and your energy working with us, not only for this interview, but for meeting with us previously to help us understand even what this was about so that we could research it, providing us material and scholarship, and being okay with the ridiculous volume of emails that I sent.
No. No. I think it's your timing is good because it is. I did. I think I probably said. I told you I was doing. This year was the centennial of the Buck trial and the centennial of the Scopes trial, which we just got through with. There'll be more this summer. You'll see things about the Scopes trial coming out. But in another 2 years will be the centennial of the Supreme Court decision, and I think that people centennials are a good excuse for talking about these things, and so a run up to that is a good idea.
Well, thank you so much. And of course, Nikki, thank you to you for being here and your excellent questions and all the research that you helped me do. The reality is that Nikki does actually the brunt of the upfront research, so could not do it without you. So thank you so much, and uh, yeah, that's it.
Yeah. Yeah, thank you. Thank you once again for your time and your expertise. This has been, this has really sort of helped shine a light and give some background to, just, a few paragraphs on a page, which was really all we had at the
Sure.
beginning.
Sure. Well, thank you. I'll look forward to hearing it.
Thank you much.
Thank you.
Well, that's it for this episode. There's so much more to talk about than we had time for, so if you want to learn more, we do suggest checking out Dr. Lombardo's book, 3 Generations, No Imbeciles, Eugenics, the Supreme Court, and Buck v. Bell. The updated edition is available on Amazon and from the Johns Hopkins University Press. It's time to wrap up, but before we go, thanks again to Dr. Lombardo for lending us his time and energy to help contextualize this very difficult case. This was our first ever interview on the podcast, and he was incredibly supportive of our efforts. As always, thanks as well to my co-host Nikki. The music in this episode was written by Studio Columna and Toby Smith and provided by Pixabay. Research was done by Nikki. Audio mixing and producing was done by me. Thanks for listening. Please subscribe, rate, and comment so other people can find us. You can also catch us on YouTube, Instagram, and Blue Sky. Our handle is @ReLitigatedPodcast. Please help us spread the word. All right. Until next time, I'm Jarrett, and this has been Relitigated. Take care.